You're doing it here? Yes. You have access to an online password, etc.
Item 1 for judgment WPL 282 of 2018.
This petition is dismissed.
For final disclosure, item 2 WPL 6656 of 2006 along with item 3.
Refer again the order, Your Lordship, in MG case number under section 33C, Your Lordship. So if you would kindly have a look through the order, that is page number, whenever it is Your Lordship, 62. Then I will come to the background of the case, two paras first I'm reading.
I have page number till 61.
Just a few order. Yes.
Page numbering doesn't tell.
Page number is 60, after 60, 61.
61.
Annexure 8. Last annexure, there is annexure 8.
Yes, an excellent. What is the date?
Date is 11/2/2000, 18/1/2006.
18/1/2006. Passed in MJ case number?
MG case number 16 of 1998.
16 of 1998. What do you want to show?
Yes. First I'm just reading, then I will come to the background. On the above, there are two respondents before the edition.
They are the legal years of the ex-employee.
On the basis of para 18 I'm reading, on the basis of our finding, I find the applicant should be paid by the OP an amount equivalent to yearly increment with VDA for the period of 27 years after fitment of wages, year-wise fixed annual bonus at the rate of 8.33, on leave equivalent to wage of 182 days, and 6 leave travelling concession allowance. In the result, it is hereby ordered to the opposite party to pay the amount against the wages computed above after full and final calculation deducting any amount paid in this regard, and as per order number 47 of certified standing order of the opposite party, within 3 months of this order, failing which applicant shall be entitled to recover the duly calculated amount as computed above through process of not together with 6% interest per annum. Now I am coming to the background of the case, Your Lordship.
You can just formulate your point and then we will see.
Yes. Certain important documents have not been.
You just formulate your point, we'll see the background.
In this case, what happened against?
You see, you have come against order under section 33. What is your main point you want?
Main point is that I have to show the order. What is the writ order? Award was passed against these respondents. Out of 9, 4 were acquitted, 3 were acquitted, 1 it seems we did not prefer, 3 were acquitted and in the criminal charge, and 3 were reinstated, and against 5 persons it was held that they are found guilty. So yes, then they preferred award, then they preferred writ. In the writ again against 2 workmen it was held that they are found guilty, but against 3, out of which these 2 are before edition, it was held that they should be the order was passed, reinstatement with full back wages. I would like to read only the order because
That's
that
it.
is
We understand that.
Yes.
Reinstatement
with back wages.
with
Back wages. Full back wages. This was the only order.
So there is already a predetermined right of the party to have back wages.
Back. Now,
What was the date of dismissal?
date of dismissal?
Read application 16796 order.
We needed the dismissal.
Date of dismissal. Because it will relate back to that date, no?
He was discharged by order dated 13/6/70.
13670. Okay.
Now, we preferred the up to Supreme Court, and that was dismissed, saying that the writ order is correct. So my only contention is, your leadership may kindly have a look through, that is the relevant thing, Annexure 3. Annexure 3, I have paid all the dues as per the writ order. That is page number 30. 34, sorry. Annexure 3. Dated 4/12/96. Date may be noted, leadership. He accepted all the amount I have calculated. I have explained how I have calculated details of back wages, basic, DA, BP, fixed allowance, conveyance, HRS, sanitation, HMA, long service, PF recovery, income tax recovery, everything. After 2 years, when accepting all the amount, after 2 years, he preferred the MG case, saying that certain things should be paid to him. There was no such order in the writ order, reinstatement with back wages.
After
Now they
how
are
many
saying-
years? After 2 years.
After 2 years, approx 2 years.
Did he disclose that he has received this amount?
That is not disputed. Yes, that is not disputed. That
Did he disclose in his petition that he has received this amount and further he has to receive
in the in the MJ case, he has stated that this amount was paid to me, but I am entitled for the bonus also, for ex gratia also, for this.
So let us see that which all component he claimed and what was your reply to those components.
I have replied also. Annexure 4, page 36.
First, let us see what all are the components which has been allowed.
Allowed.
Yes, it has been allowed for. This is increment has been allowed. Yearly increment.
Yes.
Right? Then variable dearness allowance has been allowed.
VDA.
VDA has been allowed, right? Okay. Then fixed annual bonus.
At the rate of 8.33.
8.33% on leave. $182 days.
Leave traveling,
LTC
for allowances for 6 times
6 times.
with 6% interest.
Interest 6%. Now let us see item wise. Is he entitled to yearly increment?
If leadership, kindly have a look to page 46 of my show cause. Each and every component I have explained how much and why he is not entitled. First is annual bonus, page 46.
Page 46.
Only few paras if I may be allowed. Everything
First you show me yearly increment.
Why annual bonus?
Annual bonus is not yearly increment.
किसी को किया है annual bonus?
Annual bonus is not increment. He has given bonus separately and no, annual bonus is separate. Where is fixed increment? annual increment. Where is your response to fixed annual increment?
Performance linked payment. Second is performance linked payment.
Performance linked payment has been denied to him, right? So we don't need to worry about it. You just tell us where is his claim with regard to annual bonus. Let us see his claim if you are not responding to this claim. Let us see.
MD case number, that is an issue. 4. Issue 4. Pay starts. Issue 4. Pay starts 36. Para number 10. Para 10. The components. Page 38.
A annual bonus and performance linked payment.
Yes.
Right? This is one. Second was 1 month leave,
Wages for each year
Yes.
690.
education allowance, efficiency, quality control, settlement benefit, medical expenses, benefit, sick leave. There is no such claim as fixed annual increment, yearly increment.
Performance linked payment.
Yearly increment का तो कोई claim नहीं. Okay, there is no claim of yearly increment as such. Then let us see the next one. VDA. Has it been claimed?
Variable dearness allowance
Has
has
it
been
been
paid, but he is saying that
Has it been claimed in this?
yes, VDA is there. Variable quality control allowance. Variable
This is VDA. Variable quality control.
quality control on the though VDA is variable dearness allowance. Why I asked, they said कि यही होता है variable.
ये K.
Variable quality control allowance.
Then fixed annual bonus का claim कहाँ है? Bonus का claim कहाँ है?
ये इनका पैदा होता है।
This is annual bonus with performing linked payment. Okay. Earn leave. Where is earn leave?
Or leaves.
Where is it?
Roman P.
Sorry?
Roman P. 10 का Roman P.
1 month leave benefit.
Encashment of leave total 27 months of gradually 182 days. Page
So CL. This is CL.
CL.
CL
Casual
188 days.
Casual.
Casual leave is also subject to encashment.
they have said in place of PL and CL by way of encashment of leave total 27 months and casual leave 182 days for encashment as per agreement between you.
Yes. They have given you earned leave for 182 days.
One leave for 180.
This is casual leave.
1 month leave wages for each year. Leave wages, Lordship may see.
CL तो वही है.
Leave wages, that is different. Earned leave is granted 1 month for each completed year, so 1 year.
But that has not been granted.
Yes, Lordship.
That has not been allowed.
That has been allowed, Lordship.
Whether I'm just interrupting you, Ladyship. Whether
Earned leave equivalent to wage of 182 days.
180, para 40.
Anyways, just
whether under section 33C2 this can be calculated or not, this question I'm putting to myself.
the leave traveling assistance.
Para 14 may be seen.
Just a minute. Sick leave.
Page 60.
Let her finish. You just have a seat. Okay. Continue, please.
So I'm just reading my explanation in few paras of so far everything has been explained. Annual bonus, why it should not be paid and what has been paid. Annual bonus, page 46. Only 5 paras I'm reading. Mere continuous, shall I? Mere continuous in employment does not entitle a workman to all the benefits. Under section 8 of the Payment of Bonus Act, 1965, an employee becomes eligible to be paid by his employer.
So
bonus.
this was disputed by
Disputed. It is there in the bonus.
Okay, next.
Next is performance linked. When he has not worked, whether the performance linked payment with ex gratia. Ex gratia is not mandatory; it is discretionary according to the performance.
Okay.
It's not a statutory prescription. The performance linked payment was payable to the employee of the opposite party in terms of memorandum of settlement dated so and so, subject to the achievement of year-wise productivity index as detailed in paragraph 9.3 of the said settlement in a month, and payment on
So
this
this was
account.
also disputed.
Yes, this was also
Leave
disputed.
wages.
Leave wages. As per rules of the opposite party, if an employee proceeds of sanctioned annual leave due to him, he is paid wages for the period of leave granted to him. The applicants have been paid wages for the entire period from the date of the termination till the date of their reinstatement, and it is
And
notional.
therefore there was overlapping. Next.
Now, leave travel assistance. To become entitled for the leave travel assistance, an employee has to take leave for a minimum period of 3 days. The applicants never proceeded on leave, therefore their claim for payment of leave travel
You
assistance.
have paid the entire wages.
Yes.
So
They
therefore
were
this is
absentee.
also overlapping.
They were absentee, and that's why they have been removed. Education allowance. The education allowance payable to an employee.
They have
on
not
his-
granted education allowance. You
Yes.
forget it.
Now, your ladyship, efficiency and additional bonus and quality control allowance. Until implementation of the memorandum of settlement dated 14/8/1989, effective from so and so, the technical staff grade S1 to S7 in quality assurance division were on receipt of quality control allowance subject to the observing 48 hours working per week, and those work was directly related with increase.
How these kind of
And
payment
under
could have been directed under section 33.
33C2.
Whenever there is a dispute in connection with the entitlement,
They should have moved.
if there is no
the
dispute in connection with entitlement, we can understand that it could be subject matter of computation. But when there is a dispute in connection with entitlement, how can this amount be granted under 33?
This is the only.
You have to raise an industry dispute for that purpose.
First
The
point
order of the court was also not very clear. It was only back wages.
no,
it
no,
was-
with consequential benefit.
Okay, with all consequences.
With all consequential benefit, 33C may be lost.
Yes. Idea.
Idea.
एक जजमेंट किए थे ना डीबी में, आपका केस था, आपका केस था 33C2 का जजमेंट नहीं, ऑनरेबल जस्टिस अपेश कुमार सिंह के साथ को जीता निकालिए
33C, I am reading lots. Page 47.
सिर्फ इसमें और इन स्टेटमेंट विद बैक वेजेस फ्रॉम द डेट द
आप साथ साथ क्यों बोलते हैं, आपको सुनिए, उनसे पूछ रहे हैं, मतलब आपसे कुछ सेटिस्फाइड है ना. चलिए 33C.
33C, recovery of money due from an employer. Where any money is due to a workman from an employer under a settlement or an award, or under the provision of Chapter 5852, the workman himself or any other person authorized by him in writing in his behalf, or in the case of the death of the workman, his assignee or heirs may, without prejudice to any other mode of recovery, make an application to the applicant government for the recovery of the money due to him. And if the appropriate government is satisfied that any money so due itself certificate for that amount to the collector will proceed to recover the same in the same manner as an area of lender. 2. C2 I am reading also. Where any workman is entitled to receive from the employer any money or any benefit which is capable of being computed in terms of money, and if any question arises as to the amount of money due or as to the amount at which such benefits should be computed, and the question may subject to any rule that may be made under this Act, be decided such as may be sustained by the appropriate government within a period not exceeding 3 months. Provided that when the presiding officer of a labor court considers it necessary or expedient so do, he may, for reasons to be recorded in writing, extend such period by such further period as he wishes. Now, Lord, see, when up to the Honorable Supreme Court, it has been decided that reinstatement with full back wages and consequential benefit, then automatically the learned labor court has said that had he been in service, he would have entitled. Had he been in service, he would have done. Regarding two items, the education and medical allowances, the learned labor court has said that since no evidence has been laid down, so I am not allowing this application. Now, Lordship may see the improved order, the order by which he has said. पैरा 12 पैरा 11 में है workmen pointed out together page 60 time of reinstatement these workmen received the promotion which these workmen can also have if they would have been in continuous service. Para 12 so far as the yearly increment is concerned I find that would have been given to the above workmen if they would have been in service for period of non-employment due to their termination of service. On perusal of exhibits C and C by 1, I find nothing has been given by the OP against yearly increment and area
So
of.
where is your claim of yearly increment?
Yes.
You show us. I was looking for it. Where is your claim for a yearly increment? In your petition? Where is it? Show me where is the claim for yearly increment.
Although Lordship, they have said variable quality control K in Roman K prior to identity not quality control annual increment it automatically flows.
I do not know. Where is your claim? Annual bonus and performance linked payment with ex gratia.
With effect from.
Where is your claim for annual increment?
Lordship, to that
No
effect.
such claim.
To that
That
effect,
is why there is no specific reply to that.
To that effect, Lord, my humble submission is that once he has been reinstated in service, reinstated this from the date of termination. From the date of termination, and they prolonged the joining of the both this respondent on pretext or the other. So once the order has been passed by the honorable.
You see, what will be the component of back wages with all consequential relief is itself a matter of dispute.
They have
And
disputed.
therefore, no, they will dispute. They have disputed.
They have disputed
So
it.
therefore, it requires an adjudication. Under 33C2, it could not.
Lordship, under 33C2, the court labor court.
Your entitlement, Mr. Please understand, your entitlement is in dispute. It is not just computation. Your entitlement under section 33C2 is in dispute. It requires adjudication. You can't be like this.
33C2, that power
Did it
controls
not?
as an executing court of the labor court. Lordship. That is
What will it execute?
execute.
You see, quantification has also not been done. Did you give any quantification? Did you quantify your claim? No. Did they give any quantification? No. Labor code is supposed to do what? Quantify the amount and issue a certificate for recovery. There is no quantification.
They have left it to the management
How?
concerned to
They
decide
are not
to
supposed
calculate
to.
it.
They are not supposed to. They are not supposed to leave it to the management for the purposes of calculation because they have to issue a certificate for recovery.
Lordship,
There is no computation. You have also not given your computation.
They
Where
have
is your
claimed it.
computation? Have you
They
given
have-
your computation?
they have claimed it. No
No,
computation.
no. Computation is something which is required to be done by the Labour Code under 33C2. I could have understood that you had given your computation and they were disputing something. It can't be like this.
Lordship,
It is a non-executable order completely.
That is the Lordship, in fact, the management is required to calculate the thing because they are not the competent authority.
We are not bothered about it. All your claims are disputed. Nikki. WPL number 6656 of 2006. Heard the learned counsel for the parties. This petition has been filed for the following relief. While giving the background of the case, the learned counsel for the petitioner. One petitioner or how many petitioners?
Two petitions are there. Now both of them are died, Lordship.
Yes.
Petition number 2 is presented by his widow or one by his legal agency. Substitution petition is there that has been allowed.
The learned counsel for the petitioner has submitted that the matter relates to payment of backages in terms of order passed by this court in CWJC number 38 of 1978 in bracket R. अवार्ड में ही था बैकवेजेस, अवार्ड में बैकवेजेस
Award to मेरे against हुआ था.
अच्छा
Writ may have that has been brought on record by
Yes,
way of
yes.
supplementary affidavit. That is page number 33, internal page 29 of supplementary affidavit. Last para. Sorry, what was against them? I said
What was against them? And writ application was inverse. Page 67 will be seen of the supplementary.
आप कुछ नोट बनाए हैं इसका सीक्वेंस लेके आइए ना बना के सवा दो बजे अदरवाइज यू नो देयर कुड बी एन एरर यू जस्ट गिव अ नोट व्हाट वाज द ऑर्डर एंड हाउ मेनी पर्सन्स आर एग्रीड आई गिव द डिक्टेशन व्हाट अबाउट द फर्स्ट अपील
First appeal notice, they had filed, the workman had filed it for
you can put it in handwritten also
Ah, yes.
just refer to the order
Yes.
yes 33 Yes, Madam Swati, you were citing. Swati, sorry. You were citing that judgment in one case. 33C2 judgment of division bench. It was authored by me. The number detail.
मैं देख लेती हूँ. I'll provide.
see page 30.
What was it for? Compensation.
Compensation.
Nothing to do with 33C2.
33C2 nothing.
जबरदस्ती
but
इसके
it
साथ
is-
tag करा
but they have taken a plea. Since an application has been filed under 33C2, so this application money claim will not be taken. So, my humble submission to that effect, Lordship, the petitioners have suffered a lot in the ground. They were terminated from service in 1970. 1970, and ultimately they were reinstated in service after a prolonged litigation by the up to the Honorable Supreme Court. So they have claimed if they did not provide.
Just a moment. You were terminated in 1970
1970.
on account of some charges.
On account of some charges, criminal charges leveled against us, which ultimately ended in acquittal.
There was no separate proceeding, disciplinary
No
proceeding.
separate. Only on the ground of criminal charges.
Charges?
We were dismissed.
What is the date of acquittal?
date of?
Acquittal.
That is not there, Lordship.
When did you raise the industry dispute?
When did
When did you raise the industry dispute?
this dispute was raised, Lordship,
After acquittal or before acquittal?
after acquittal.
After acquittal. When was it raised?
The dispute was raised in 98.
1998.
Uh,
Okay, after acquittal.
after.
And then in the award, you were ultimately award was against you.
Ultimately, award was against you. Writ application was filed. In writ application was allowed in my favor. The management
Okay,
went to
writ
the
petition was CWJC number 140,
140 of
1978 within
R.
bracket R, right? Allowed.
दो रीड
दो रीट था, एक मैनेजमेंट भी किया था, 140 है.
आपका कौन सा?
My read is
मैं इनका रीट पूछ रहा हूँ. आपका रीट कौन सा था?
मेरा read है CW.
आपका नहीं पूछ रहे मैडम.
Oh, sorry.
दोनों साथ में आप बैठ जाइए ना.
Sorry.
जब तक आपसे ना पूछे तब तक समझ लीजिए इनसे सेटिस्फाइड नहीं है, बैठ जाइए।
I was reading it.
नहीं, नॉट रिक्वायर्ड। हाँ बताइए।
ये है रिट पिटिशन है 38 of 78.
38 you filed it,
Yes, ma'am.
okay? It was allowed when?
Thirty-eight was filed by the management and 40 of 1978 that was filed by the workman.
उसके बाद सुप्रीम कोर्ट से अल्टीमेटली डिसमिस हो गया।
Dismissed.
Then you wanted compensation.
Compensation.
You have got the relief of back wages.
Back wages
You have got
relief.
the relief of consequential relief. If
But
you wanted some more amount on account of victimization, etc.,
Victimization lots.
the matter could have been given by the writ court itself, isn't it?
But the writ court lordship may see this page 14 only. The claim for which we have claimed compensation, monetary claim, that I am reading. Second line. To reinstate the service of the plaintiff number 1 is husband as per order that is 16/7/96. It is further case of plaintiff the defendant company reinstated plaintiff number 1 and husband of plaintiff number 2 and former retired after 2 years from rejoining the service. However, the latter died due to heart failure inside the factory after 2 days from the rejoining of his service. Here I am just mentioning to your lordship that petitioner number 1 KK Murmu, he was reinstated in service on 8/10/96.
8,
October 96.
10, 1996.
And number 2, he Grinal Das Gupta, he was reinstated on 16/10/96.
How many persons are there in this one?
There are other persons, but I am not concerned about the 2 persons for which I am
You are
not.
concerned with only two
Only 2
persons.
persons. 10, 16,
Kumar
10,
Krishna Murmu
हाँ,
and
and Grinal Das Gupta.
Murmu and Rinal
Das Gupta.
Das Gupta.
हाँ. Krishna Kumar Murmu, he was reinstated in service on 8/10/96, and Grinal Das Gupta was reinstated in 16/10/96.
16, 10,
96.
After acquittal in 2 years.
And thereafter, Grinal Das Gupta died on 30/10/96.
Right. Okay.
And
What
now-
about KK Murmu?
KK Murmu, he superannuated from service on 10/10/98.
10,
10/10/98. And in CWJC number, by judgment dated 21/1/83, 21st January 1983, Labour Court award was set aside and workmen directed to be reinstated with back. That is the fact of the case. Matter went up to Supreme Court and
No, that's right. So
Yes.
what are you claiming for?
because of sufferings and due to the dismissal of the petitioner, he has said,
You see, for the purposes of dismissal, whatever you have suffered, whatever consequential relief you get out of suffering, has to be taken care of by the Labour Court. What other damages are you claiming?
damages in the sense, Lordship, just I am showing Lordship what he has claimed. I am reading it from 4th line. Inside the factory, after 2 days from the rejoining of his service due to weak health and caused by non-providing of medical help, there is the plaintiff number 1, Krishna Kumar Murmu, he, and deceased husbands of plaintiff, including the family members of both the plaintiff, have been suffering continuous for 26 years and 6 months due to mental agony and torture. And also they have defamed the society due to starvation, lack of education and material facility, and also due to defamatory action against them made by officials of the defendant company. However, defendant company is duty bound to provide statutory medical and educational facilities by reimbursement, and they have suffered irreparable loss in career of their children, and career of the children were ruined due to non-availability of the sufficient funds. Lordship. On these grounds, Lordship, they had claimed after their dismissal, they were penniless. There was no money with them. Ultimately, when they were reinstated by the Honorable High Court and Supreme Court, they were granted money. But 26 years of precious life that has been spent in litigation with
That is why you have got money without work.
money is.
Yes. Consequential relief of full back wages with whatever. Right? That is why you have got that.
That has been paid loss. I have said. And main ground they have taken since a petition has been filed under 33C2, so this money suit is not fit to be allowed on this. That will be
That
complete.
is not the finding. The finding is that you are not entitled. In a criminal case, you see, the criminal case was instituted in 1970,
70.
right?
Yes, ma'am.
And till 1998, you did not take any steps. You were fighting out your criminal case, right? Your suffering started only when you got acquittal in the criminal case, right? If you were wrongly, if there was some malafide in your prosecution, you have a remedy under the criminal law itself, isn't it?
Yes, sir.
For false implication, you have a remedy under that. But you are seeking compensation.
Compensation. They have said compensation.
And they could not have reinstated prior to 21/1/1983 because till that time there was no order in your favor, right?
Ultimately, Lordship, the order was passed in my favor in 21/183 by this honorable. In CWC 140 of
So you were supposed to get back wages till reinstatement.
till this.
So whatever be your date of reinstatement, if they were not taking you back, then under such circumstances you could have filed an execution case. There are so many remedies under the labor law. You file a money suit for that. Claim compensation.
In fact, Lordship may see issue number 4 that has been decided in my favor. Issue number 4 is
Yes.
issue number 4 is whether the suit has been properly valued.
It is the valuation.
Valuation.
Issue number 4 is valuation.
Valuation. And issue number 5 is whether the defendant company has committed tort of malicious prosecution against the plaintiff, husband of plaintiff, with their reputation in society is lowered down so as to be.
Malicious prosecution will be decided in the civil suit. Or malicious prosecution as a remedy under the criminal law.
That has been decided.
There was a
against-
malice.
No. It has
Then?
not been.
तब तो हर एक केस में कितना सूट फाइल होगा डैमेजेस का. ये सारा डेट्स मुझे चाहिए, ठीक है? कब रिस्टेट हुए, कब हुए?
215.
हाँ 215 में आएगी. इसका थोड़ा एविडेंस तो फर्स्ट अपील है तो एविडेंस डिस्कस करना ही पड़ेगा, उसके बिना तो नहीं हो सकता. We will frame the point of determination and then point of determination बताइए. You frame the point of determination. Yes, tell us. You frame the point of determination.
In Roman 3 Lordship, grounds we have formulated and we have stated that relief of reinstated food including other relief against the defendant company by judgment passed in CWC number special leave petition so and so. Direction was made to the defendant reinstate the service of the
I am asking you to formulate the point of determination.
for date of formulation. That is the point, Lordship, due to the wrong action and termination of the petitioner. They were ousted from service for 26 years. They were ousted from service for 26 years, and as such, the children of the appellants suffered heavy loss in their education, medical treatment, and loss of reputation in the society.
Did you exhibit the order of acquittal? Was it an exhibit before the court?
That was not
Then how will the court determine what is the nature of acquittal?
that was not exhibited.
So,
Only they have documentary evidence में certified copy of the order.
आप छोड़ दीजिए ना वो क्या किए, आप बताइए क्या किए, सूट आपका था ना,
Court to the
बस एमजे केस का ऑर्डर लगा दिए. And you claim malicious prosecution. कुछ आपको नोट वोट्स नहीं बनाए, छुट्टी में कुछ पढ़ाई वढ़ाई नहीं किया मिला?
जी.
हाँ बताइए.
LPA 379 of 2012.
LPA 379 of 2012.
CCL versus Siraj Mian and others.
आप थे? हमारा ऑफिस डिपंक नहीं मिलता है.
I'm sending that to you.
हाँ प्लीज. So your entire claim was based on the basis of your 33 C2.
yes.
You have exhibited carbon copy of legal notice and postal receipt. ठीक है, इसको भी लिखाएंगे साथ में. आप लोग का सबमिशन ठीक से रिकॉर्ड कर लेंगे एंड देन आई पोस्ट इट फॉर जजमेंट. Just get your things done as per the judgment of the student. Because this dictation will take more than half an hour. नहीं इनको सबमिशन लिखाएंगे ना सीक्वेंस में नहीं हो सकता. You come, please come in the second.
Item 4 WPS 6902 of 2017.
Next petition.
There was a direction upon us with respect to the paper publication. There was a pertinent question by Nitisha on the previous day that why the publication has been made in Ranchi. In Hindi newspaper, it is Hanwani. Ladyship, Ranchi only circulates.
Okay. They are not entered appearance.
No, they have.
Right.
Yes.
Orders में नहीं है ना it is.
Final disposal. Yes. The facts I am stating, and then what is by I have a very small grievance. The fact is, the father of the petitioner was appointed on 10/8/1979. He superannuated on 9/5/2005. Gratuity was calculated, and finally, the gratuity was paid along with LLTC, total amounting to rupees 61,747 on 22/8/2012. The check was duly received by the respondent. And thereafter, the case was filed under the Payment of Gratuity Act in the year 2013, claiming
Check
that
was received or it was encashed.
it was received by.
Receipt of check is of no consequence.
That has to be, I'll just verify that as well. Then the case was filed under the Payment of Gratuity Act in the year 2013, claiming that his father died in the year 2007. Ladyship, the difficulty on my part was, even after we did not adduce any evidence before the court bill, and hence it was calculated on the date of 2007 and the relevant pay scale at that particular time, considering his length of period of service till 2007, though he superannuated in the 2005 itself. So our only grievance is to the extent that whichever is earlier, whether it is 2005 or 2007, and the pay scale that is applicable on that day, the gratuity has to be calculated as well. We preferred an appeal. Appeal was not decided on merits. It was dismissed on the ground that it has been referred beyond the limitation period of 60 days.
Where is the order of the adjudicating authority? Where is the order of the adjudicating?
Annexure 1 may kindly be seen, that is the order. That is the award.
Is there any ceiling?
Check.
Is there any ceiling?
Ceiling.
Ceiling on the gratuity amount
Ceiling
with regard to gratuity?
अभी तो अलग है मतलब, but
I do
as
not
per-
know कितना था इस समय. इससे कम ही होगा.
हाँ, 3 लाख कुछ कैलकुलेट हुआ था. 3,52,300 was the calculated amount. Considering his length of service as 33 years, 6 months, 28 days. And his last drawn wage 650 as per the NCWA applicable at that relevant point of time, that is in the year 2007, though he superannuated in the year 2005 itself.
So the applicability of NCWA would also change.
Yes, that would also.
What is the proof regarding his date of superannuation?
We have sent a letter ready because since we did not adduce any evidence in the court
You
below,
must have put something in the writ.
I have in the writ application we have simply stated all the documents because the documents were not placed. So annexure 1 is the award, then there is annexure 2 which is the form R. Annexure 3 is the letter of intimation to the court below that these are the facts and we could not produce the documents because we could not trace the documents at that relevant point of time. That my letter is at annexure 3 starts at page number 24. And thereafter we preferred an appeal leadership along with the relay condemnation application, and annexure 5 is the appellate order.
Where is your application for condemnation of delay and what was the period of delay?
In our memo of appeal also at para 7 we have mentioned the reason for the delay.
Where is your petition for condemnation of delay?
It starts at page 20.
Page 29 is the petition for condemnation of delay.
Yes. Petition for condemnation of delay in filing PG appeal under such and such. That was before the act.
And what is the present stage? Are you for the private party?
No, for this time.
This order has been executed. This order has been executed so far. No idea.
Maybe. Because the appeal is pending, so the WPL matter is pending here in this.
Where is your form L?
For R is there.
R.
Yes. That is annexure 2. At page number 23.
They must have paid this amount. They must have disbursed this amount.
Let the matter be in the coming week. I will seek instructions if at all the amount has been paid.
And this person has already died. The employee has already expired.
The employee expired. Thereafter, this application was preferred by the defendant, showing that he died in the year 2007, suppressing the fact that he superannuated in 2005 itself.
So why didn't you file your written statement?
Yes, we did not. That is the lacuna on our part before the court below that we did not. Hence, we filed an application before the court below that certain documents could not be produced. because it was not traceable at that point of time, and thereafter when we got hold of all those documents, we preferred an appeal also, and we wrote a letter to the court below also.
What do you say?
Actually, we are a formal party.
आपको कुछ नहीं बोलना है, फॉर्मल ऐसे ही खड़े रहेंगे.
Lordship, but the costing which petitioner is Lordship paying, that is the order passed by this Lordship Deputy Chief Labour Commissioner Central Lordship. So we have no role to play in this matter.
Then why are you standing?
Because we have.
You are not required to address the law.
Yes, Lordship.
Then
Lordship, but no counter affidavit has not been filed.
for addressing the law, you need a counter affidavit.
Union of India is the party, and respondent number 4 is Shyam Kishore Belgar, the private respondent.
Why two orders have been annexed? Same, maybe one is a certified. Was notice issued to the private party at the stage of appeal? No.
No.
In spite of substituted service of notice, nobody has entered appearance on behalf of private respondent. Within bracket, respond number 4. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that an order was passed, has submitted that the ex-employee, namely name of the ex-employee, what was his name?
Some Hari Prashad.
Namely Hari Prasad. Was in the employment of the petitioner since 10/8/1979, and he attained the age of superannuation on 9/5/2005, and consequently certain post-retirement benefits, including gratuity with LLTC, was paid. Sorry,
The receipt we had enclosed with the letter
where is it?
that in Exhibit 3, page 25, the same check first from the first application. Consisting gratuity amount such and such. The same check had been received by Sri Shyam Kishore Bildar from our office, and the copy of the receipt is enclosed.
And the check amount arising out of the post-death benefits was received by son of late Hari Prasad, that is Shyam Kishore Baldar, on 22/8/2012, as Hari Prasad had expired in the year 2007. The learned council submits that thereafter, in the year 2013, Shyam Kishore Baldar filed a petition before the controlling authority under the Payment of Gratuity Act. It was numbered as PG case number 36, 34, post of 2013, P-4. And in the said case, no show cause was filed by the petitioner. Consequently, the controlling authority passed an order directing payment of gratuity up till the date of death of Hari Prasad, who died on 9/2/2007. The learned council submits that if the date of superannuation is taken into consideration and the payment made to Shyam Kishore Baldar is also taken into consideration, then the applicable national coal wage agreement will also change,
That would be NCWA 7. We have taken
and the ex-employee would be governed by NCWA
7.
Roman 7. The learned council has submitted that the entire computation and payable amount will be altered if the date of superannuation is taken as 9/5/2005. The learned council further submits that that said Shyam Kishore Baldar, his son, was also under a legal obligation to disclose the receipt of the check on 22/8/2012, arising out of death benefits.
Date of superannuation as well mentioned.
Sorry.
And date of superannuation.
And date of arising out of superannuation benefits. The learned council further submits that after passing of the order by the controlling authority, an appeal was filed before the appellate authority, who dismissed the appeal by citing that the appeal was filed beyond the prescribed period of limitation and beyond the period of condonable delay. The learned council has referred to the petition seeking condonation of delay, which was filed before the appellate authority as contained in Annex 4/1, and has submitted that the order of the controlling authority was passed on 12/8/2015, and the petitioner serves the relevant records and the payment made and the date of retirement. An appeal was filed thereafter. She has also submitted that a petition was also filed before the controlling authority intimating the state authority with respect to the aforesaid facts. You are for the state?
Yes, Lord.
The learned counsel for the state is present. The learned counsel submits that the matter is between the petitioner and the private respondent, and he has nothing much to say. After hearing the learned counsel for the parties, our learned counsel for the petitioner and state, this court finds that it is not in dispute that Hari Prasad was an employee of the petitioner, and he died on 9/2/2007. It is further not in dispute that his son, namely Shyam Kishore Beldar, filed an application before the controlling authority of Payment of Gratuity Act in the year 2013, claiming gratuity. It is further not in dispute that the petitioner did not file their show cause before the controlling authority, and consequently the controlling authority passed an order for payment of gratuity till the date of death of Hari Prasad, that is 9/2/2007, from 10/8/1979, which is the date of initial appointment. After the
If I may kindly be permitted, the date of appointment has been taken by the Labour Court as 11/7/1973. That time he was a casual worker.
The date of appointment has been taken by the Learned Labour Court as
11/7/1973.
11/7/1973, the date on which he was appointed as a casual employee, as submitted by the Learned Counsel for the petition.
And his services were confirmed and appointed. He was appointed as a regular employee on 10/8/1917.
And he was appointed as a regular employee on 10/8/1979. After the order passed by the controlling authority, the petitioner filed appeal before the appellate authority, seeking condonation of delay. The appellate authority dismissed the appeal by observing that the period of limitation for filing the appeal is only 60 days, and in addition the prescribed period of 60 days and in addition there is a provision for condonation of delay of further period of 60 days. The period having expired, the appeal was filed after lapse of more than 20 months. The petition for condonation of delay, there is no dispute that the authority under the Payment of Gratuity Act are governed by the Act and the rules, and the appellate authority does not have the power to condone delay if the appeal is filed beyond period of 120 days. सेवा सदन का केस है, सेवा सदन का केस है. A reference in this regard be made to the judgment passed by Honorable Division Bench in the case of Seva Sadan citation. There. This court finds that so far as the appellate authority is concerned, there is no error in the order passed. Once the appeal is dismissed on the ground of limitation, there was no occasion for the appellate authority to enter into the merits of the case. This court also finds that the petition filed for condonation of delay is also sketchy, inasmuch as even the date on which the documents could be retrieved has not been mentioned. Further, the petitioner is not only disputing the date till which the ex-employee was entitled, but is also disputing the period of employment, the period for which the ex-employee was entitled for gratuity. In view of the aforesaid facts and circumstances, this court is of the considered view that there was no cogent explanation for seeking condonation of delay over and above the fact that the appeal itself was filed beyond the condonable period of delay. Accordingly, there is no merit in this petition, which is hereby dismissed. I will add something more also. एक और हम डिस्कस करेंगे ऐसा आपका
पर हो सकता है सर अपनी
हम किए very recently किए. This review is also not maintained. That petition was of no consequence. वो judgment हम खोजेंगे तो उसमें से review डालेंगे.
Item 5, WPL 2738 of 2018.
Yes, petitioner.
Prayer for quashing the award dated 18/12/2017, class in reference case number 3 to 2011, where learned presiding officer labor court has pleased to negate the industrial dispute. Learned labor court and even finding that departmental proceedings were fair and proper. And the punishment was proportional to the proved misconduct, as workman has lost confidence of the employer and workman was holding his post of trust and confidence.
Did you admit your guilt?
Yes, sir.
What else? Once you admit, what else is there?
If Lordship allows me, I would like to refer to two which are already in exhibit, Lordship, that will lead to the emphasis of victimization and unfair labor practices.
It was a case of victimization. It was a case of victimization.
No, Lordship. But at the before the labor court by the supplementary petition on the issue of victimization and also by way of amendment was filed.
That was rejected. Correct?
Lordship, one
Once
exhibit-
you admit your guilt, the matter ends. What else is required? It was a case of theft. What was the case?
case was Lordship, that without physically verifying the stocks or consignment of tire, he signed the charge. Lordship, earlier occasions also, tire were unloaded in different areas. It has come in the inquiry report also. And on the advice of Mr. Pati, who was the supervisor, he signed. And this has come on the inquiry report also. Lordship, I would like to, Lordship can consider Exhibit 6.
You tell us the perversity involved. What is the perversity involved? The departmental proceeding was held to be fair and proper. What is the scope? Proportionality is to be seen, and whether the charges were proved or not is required to be seen.
Charges are proved, Lordship.
Charges were proved. Now, whether it is the court has given reasons to hold that there was a loss of confidence is sufficient to sustain the order of dismissal.
Lordship, two more persons were also involved in same, but they were never booked. FIR was never.
That is not negative equality doesn't. There was an FIR.
Yes, Lordship.
You were convicted.
Acquittal.
Acquitted. When were you?
Yes, Lordship.
When were you acquitted? Did you exhibit the order of acquittal?
Yes, Lordship.
Where is it?
Annexure 8, Lordship, page number 25.
Acquittal was prior or later?
Letter, Lordship.
9/4/2018. When was the order of Labour Court passed?
The Labour Court passed. 18/12/2017.
Acquittal 19/4. Who were the witnesses in the departmental proceeding? Who were the witnesses in the departmental proceedings? Where is the inquiry report?
Lordship, page number 43.
Is the inquiry report?
Yes,
Yes. Read the inquiry. Summary of inquiry. Who were examined? Mr. Amarjit Singh, right?
yes, Lordship. Yes.
And Mr. H.P. Chaudhary, manager.
HP Chaudhary, Lordship.
and
R.K. Singh, Lordship.
sorry,
Assistant Manager, Security.
R.K. Singh.
Yes.
You did not cross-examine any of the witnesses.
Yes, sir.
And who were the witnesses in the criminal case?
PW1 Vivek Sakshen is that findings page number 37. Where do you see PW1 Vivek Sakshen, informant and agreed. PW2
There is not even one common witness. And at the end of it, you also admitted your guilt.
Yes.
Where is that admission recorded? The charge of negligence of duty as well as deceptive or corrupt practice leveled. So there was a charge of negligence of duty also, which was not subject matter of consideration in a criminal case. The charges were also not the same. क्या करना है? क्या बोलना है आपको?
Your Lordship, that was never challenged, Your Lordship, and it was held proper, fair and proper, and it was not once, twice, it was done. The challan was being issued by him, and the material was not delivered to the company, Your Lordship. So, in absence of proper explanation, he has not examined any witness, only examined himself, and the learned court below has found that it was fine. The domestic inquiry, it was fair and proper, and so it requires no interference. The management has lost its confidence. For theft, there is several judgments. Your Lordship, some of the judgments are
Not
passing.
WPL number 2738 of
6
2018.
judgments are.
WPL number 2738 of 2018. Or the learned counsel for the parties. This petition has been filed challenging the award dated 18/12/2017 passed by learned presiding officer Labour Code Jamshedpur in reference case number 3 of 2011. Whereby the reference has been decided against the petitioner, against the partner. The learned counsel for the petitioner submits that arising out of the same occurrence, a criminal case was also instituted, and the petitioner has been acquitted in the criminal case on 19/4/2018, whereas the impugned order was passed by the learned Labour Court on 18/12/2017. He submits that acquittal of the petitioner has a bearing in the present case. The learned counsel has also submitted that the petitioner was not solely responsible for the issuance of challan and the petitioner had acted under the instructions of the supervisor. He has submitted that considering the nature of allegation, the punishment was disproportionate to the charges proved. The learned counsel has submitted that the charge was primarily in connection with negligence in duty. He has also submitted that a petition was filed seeking amendment in the written statement, raising the plea of victimization and unfair labor practice, but such amendment was declined by the learned labor. However, The present case is a case of victimization and unfair labor practice. That's all. The learned counsel appearing on behalf of the respondent while opposing the prayer has submitted that
Section 3. It is alleged. Page 30.
the petitioner was charged for habitual negligence or neglect of duty and deceptive or corrupt practices. It was alleged that the petitioner had acknowledged the receipt of consignment of tires on challan, but the same was never reported to have been unloaded at the area where it was sent.
Challan.
The details of the challan number has also been mentioned in the charge sheet. She submits that by a specific order, the preliminary issue regarding fairness of domestic inquiry was decided and it was held to be fair and proper. It was only after such decision the petitioner sought to amend the written statement by making allegation of victimization and unfair labor practice. She has submitted that the learned court has rejected the amendment, it was an afterthought, and further the improved order has been decided by within the contours of section 11 capital A of Industrial Disputes Act. She has also submitted that the acquittal of the petitioner in the criminal case, though after the passing of the improved award, has no bearing in the matter, as the nature of allegation and the evidences adduced are totally different, though they arise out of the same incident. The learned counsel has submitted that there is no perversity in the improved award, and accordingly the same does not call for any interference. There was complete loss of confidence by the management, which has been taken note of by the improved order. She has relied upon the judgment passed by the Honorable Supreme Court.
Report and coordinate LPA bench. Scope of interference, loss of confidence, case of theft.
पैरा नंबर नहीं लिखी,
दूसरे वाले का scope. First one is scope of labor code when there is no victimization. Second one is para 6. Third
अब
one,
ठीक से पैरा लिख लीजिए और लिस्ट ऑफ जजमेंट्स दे दीजिए, ठीक है?
सबका लिख दिए बस एक का.
आप ठीक से पेन से लिखिए ना, फोटो कॉपी में आ रहा है, ठीक से लिख के बताइए, उनको हाईलाइटर भी दे दीजिए. The learned counsel has relied upon following judgments. ये judgments and paragraph 2. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that following charges were leveled against the workman. इसको quote करना है, page number 30 से. The workman was charged under subclause Roman 4 and Roman 15. Roman 4 है habitual negligence or neglect of duty or work. Roman 15 is deceptive or corrupt practices. The inquiry report has been placed on record. From the perusal of the inquiry report, it appears that as many as 3 management witnesses were examined, but the workman, in spite of given opportunity to cross-examine the witnesses, did not choose to cross-examine. The workman, however, gave his statement and he stated that he was an E4 grade employee working in materials division initially for about 12 years. His main job was only feeding the production department with tire and wheel rims. On being promoted to E4, he also started doing the job of receiving tires and wheel rims since last 1.5 years. After explaining his job of receiver, he further stated that on some occasion tire had been unloaded in other areas such as FDY, CTR and CMS. In these cases, on the verbal assurance of Mr. Pati, his supervisor, that he had confirmed the vehicle had been unloaded and signed the challan and released the vehicles. He further stated in his statement that with respect of receipt of challans mentioned in the charge sheet, he had merely signed on the challan as OK, based on the OK remark written by the supervisor, Mr. Patel. During the inquiry, ultimately, he was found guilty of the charge of negligence of duty as well as deceptive or corrupt practice. The learned labour court decided the validity of the domestic inquiry by a separate order dated 29/6/2013, and it was held that the inquiry was held fair and proper. This court has gone through the order dated 29/6/2013 and finds that the same is a well-reasoned order. This court also finds that after the inquiry was held to be valid, a petition for amendment was filed seeking to introduce further grounds to challenge the order of dismissal. That is, trying to make out a case of victimization. The amendment was also dismissed by a reasoned order. The learned court ultimately decided the case within the contours of section 11 capital A of Industrial Disputes Act and held that the workman was a material associate grade 1 and by virtue of the post was dealing with the materials of the department and was holding a post of trust and confidence. The Labour Court also recorded that the workman was holding a post of total trust and confidence and therefore the management was justified in dismissing the workman on the basis of proof misconduct. The findings of the learned labour court in paragraph 11 to 13 are as under. This court finds no illegality or perversity in the improved award passed by the learned labour court dated 18/12/2017 calling for interference under Article 226 of the Constitution of India. However, it is also to be taken into consideration that the petitioner has been acquitted of the criminal case by a subsequent judgment dated 2013 the judgment?
19/4/2018. 19/2018. Page number
Page number
41.
41. By judgment dated 19/4/2018, upon perusal of the same judgment, it appears that the petitioner was charged for offence under section 406, 407, 408, 409, 467, 468, 471, 420 and 120 capital B of the Indian Code. And 2 persons face the trial. At the stage of trial, the set of witnesses produced on behalf of the prosecution was totally different from the set of witnesses which were produced in the domestic inquiry. The nature of allegation was also different, inasmuch as the petitioner was charged of negligence of duty also in the domestic inquiry, but the same was not subject matter of consideration in the criminal case. Considering the totality of facts and circumstances, this court finds that the acquittal of the petitioner in the criminal case by judgment dated 19/4/2018 has no bearing in the present case. This is over and above the fact that the order of acquittal has been passed after the order passed by the government. Therefore, the judgments differ. It heads me 1974, volume 3, SCC 712, para 5. It head 2018, within bracket 1, JCR 159, JHR, para 6. These 2 judgments are dealing with the scope of inquiry before the labor court. Once the inquiry is held to be fair and proper. Yeah, na?
On those only management of subject period, that is a loss of confidence.
Okay. Para 30 of judgment passed by Honorable Supreme Court reported in bracket 2018, bracket close 1 SCC 285, to submit that once the confidence is lost, the order of dismissal is justified. On the same line, the High Court of Kampong, Katak,
It is on loss of confidence. Several judgments of Supreme Court have been referred.
ना एक जजमेंट काफी नहीं है क्या? कहाँ पहुँच?
ठीक है.
And on the same line, M.Y. खान तो हमें बेस्ट किया, हाँ?
इसमें लिखा हुआ नहीं.
मेरा केस नहीं पता.
अच्छा.
And also judgment reported in bracket 2009, bracket close. And also judgment reported in 2009, SCC online 660.
देखे नाम नहीं लिखा, तो नहीं लाते.
चलिए इसमें एक जजमेंट और है. 2014 SCC online 2689. लास्ट वाले का पैरा 7 है और इसका पैराग्राफ Roman 8. Paragraph 5 का Roman 8. ये M.Y. खान का. This petition is accordingly dismissed.
Item 6 WPC 2381 of 2021.
Leadership, the admin council says my son is out of India. Leadership, he will be here by tomorrow. So I pray for not today.
आउट ऑफ इंडिया है तो कल कैसे करेंगे?
He is in flight bound to New Delhi.
उसके बाद बोलेंगे जेट लैग.
He will be here by tomorrow.
क्या मैटर है बताइए? मैटर बताइए.
For direction upon the respondents for dispossessing the from the restraining the respondents from dispossessing the petitioner from Rayati land over an area of 15.08 acre in plot number 1421, 1422 and 1510 under RS Khata number 210 in Moza Mangara in garb of Eklavya Ashram.
How this status will be decided by this court? कौन सा मैकेनिज्म हम लोग लगाएं? Status will be decided. You have been dispossessed? आपके पास फाइल है? पढ़िए.
But your leadership, I do not have
Just
any specific.
कोई बात नहीं, हम आपको टाइम देंगे, लेकिन this is for Mr. Sahni to see.
I am the Rayati owner who leadership and the needs of
वही हम आपको दिखाना चाहते हैं. आप जो रैयती ओनर की कहानी सुना रहे हैं ना, पैरा नंबर 34 पढ़िए तो. पैरा नंबर 37. पैरा 37 पढ़. Read पैरा 37.
Page 27. Page 27.
हाँ, पढ़िए पैरा 37. पढ़िए. Read it please, yourself.
that during the regional survey, the land measuring an area of 1.20 acres comprised within CS Khata number 60, CS plot number 664 became part of RS Khata number 210, RS plot number 1422 of Moza Mangra, district Latehar, and 0.74 acres of land CS Khata number 60, CS plot number 730 became part of RS Khata number 210, plot number 1422. However, on account of due negligence and mistake on part of the Anchal Ami,
ये
the
जो है
land
ना, ये
measuring
नेग्लिजेंस एंड मिस्टेक, ये रिट में नहीं डिसाइड हो सकता. होगा क्या? बताइए.
however, on account
बस
of
बस
due
काफी है.
negligence-
काफी. Any immovable property has right, title, interest and possession. ये चार component होता है of any immovable property. These are absolutely matter of evidence. नहीं होगा यहाँ पे ऐसा. कोई एंट्री गलत हो गया. As it is, you have been dispossessed. अब तो स्कूल बन चुका होगा.
It is ready only because of this case हम लोग उसको हैंड ओवर नहीं कर पा रहे.
ऐसा है कि आप सूट फाइल करके रिकवरी कर लीजिए. You have already been dispossessed. यहाँ से कैसे क्या होगा? अब कल सुनो.
Tomorrow, it may be fixed at 2:15.
आपके टाइम.
No, leadership, I listen.
प्रीवियस ऑर्डर्स में सर्कल ऑफिसर को क्यों बुलाया गया?
It was for just to assist your lords. कि उनका appearance by way of ये नहीं था, punishment नहीं था कि उनको रिकॉर्ड लेके आने बोलिए, but just for assisting your lords उनको बुलाया गया था.
the court has also framed an issue whether the land is rayati or not.
Yes, that we have.
Whether the land is rayati or not is itself a matter of evidence. यहाँ से तो डिक्लेरेशन नहीं होगा लैंड रayati. कितना ही आपको लैंड रिसीट रेंट रिसीट क्यों ना इशू हो.
One more thing is here, Your Lordship, that we have been categorically taking this stand that the plot khata number 210 has is government land, and on that only the school has been constructed, not on his plot, Your Lordship. This is
Okay, the physical location of the
Yes.
property is also different
yes, yes,
as from what he is claiming.
yes.
नोट बना के लेके आइए आप भी. ठीक है, कल सुनते हैं सवाल. कल टाइम मत मांगते हैं, अब शुरू नहीं था. WPC number 2381 of 2021. The learned counsel for the parties are present. Counsel for the petitioner seeks adjournment and submits that the arguing counsel will be available tomorrow. Post this case tomorrow at 2:15 to be taken up as first case.
For orders item 7, WPC 4309 of 2014.
The instant read petition has been filed against the order of the BIADA and the respondent authority in which the allotment of the land of the petitioner of
Allotment
land.
कब
Yes,
था?
industrial. Allotment was there.
In this
Loan
case,
भी
Your
है
Lordship,
सर.
petitioner had died.
लोन भी है इसमें पंजाब नेशनल बैंक का.
नहीं नहीं कोई लोन नहीं.
नहीं.
उसमें इसमें जांच भी हुआ है, इसमें नहीं आया है. लेकिन इसमें पिटिशनर हम रिकॉर्ड देख रहे थे, उससे पता चल रहा था पिटिशनर डाइड हो गए 13 अगस्त 2018 को.
Restoration में
सब्स्टिट्यूशन
change
पिटिशन
हुआ
फाइल
है.
नहीं हुआ है.
पहले DFT हो गया था केस.
तो रेस्टोर कौन कराया?
उसके बाद रजिस्ट्रेशन उनके जो पार्टनर थी वो कराई, उनकी वाइफ.
और अभी यहाँ पे कौन?
वाइफ
यहाँ पे कंपनी
वाइफ
है
है.
प्रोप्राइटर.
लेकिन नाम चेंज नहीं हुआ, वाइफ ही है.
प्रोप्राइटरशिप
वाइफ ही है मतलब.
प्रोप्राइटरशिप थ्रू कंपनी ये केस फाइल हुआ था.
कंपनी नहीं है प्रोप्राइटरशिप.
यस सर.
तो प्रोप्राइटर मर गया तो क्या हो?
नेम ऑफ द
Substitution नहीं
प्रोप्राइटर हैज बीन चेंज्ड.
सब्स्टिट्यूशन पिटिशन फाइल ही नहीं हुआ.
अजित कुमार सिन्हा इज द प्रोप्राइटर. सब्स्टिट्यूशन
He
नहीं.
was died on 13 August 2018.
But the registration petition was filed on the name of her wife, namely
अभी अबेट हो जाएगा प्रोसीडिंग. सब्स्टिट्यूशन नहीं फाइल किया. प्रोप्राइटर इज वन एंड द सेम पर्सन. प्रोप्राइटर एंड द पर्सन आर वन एंड द सेम.
yes,
Partnership will be sued in the name of the firm. Company will be sued in the name of the firm. Proprietorship firm जो आदमी है बस
partner
वही.
without partnership has been annexed with the
ये पार्टनरशिप का
document.
कहानी नहीं लिखे ना, थ्रू इट्स प्रोप्राइटर लिखे हैं. तो पार्टनरशिप कहाँ से लाए?
registration kindly registration petition.
रेस्टोरेशन से क्या मतलब है इसका? गलत हो गया है. हम रेस्टोर किए हैं. हम किए हैं रेस्टोर. गलती तो हो गया. गलती को परपेचुएट नहीं करें. रेस्टोरेशन तो आप लोग कुछ भी फाइल कर देते हैं, मिसमैच रहता है. क्या किए आप इनका कैंसिल कर दिए?
ये 93 में अलॉटमेंट हुआ
क्या
था.
क्या चल रहा है इसमें?
कुछ नहीं, कोई काम नहीं करे. इसमें सीबीआई जांच का भी ऑर्डर हुआ था. सीबीआई भी जांच की रिपोर्ट दी है कि 2006 से यूनिट बंद है.
और आप तो कैंसिल 2004 में कर दिए.
हाँ, हम पहले ही कैंसिल कर दिए.
कैसे कर देंगे कैंसिल? किस ग्राउंड पे
नहीं नहीं, हम
कैंसिल?
2004 में कैंसिल नहीं किए, हम 2014 में कैंसिल.
2004 में cancel.
इनका कैंसिलेशन का ग्राउंड डेवलप की हमने एफसीआई का माल को रखा हुआ था.
वहाँ पर भाड़ा पर
गवर्नमेंट का सारा चीज हमको रखने के लिए बोले. रेस्पोंडेंट बियाडा के जो चेयरमैन है वो डीसी और सारे अथॉरिटी, हम एफसीआई का माल रखे.
क्या प्रॉब्लम है भाई?
इसी
एक
ग्राउंड पे
प्लॉट को, एक इंडस्ट्रियल प्लॉट को बर्बाद कर दिया ना इतना सन. क्या
कुछ काम नहीं कर रहे थे वहाँ पर, कुछ नहीं कर रहे थे. बंद.
एफसीआई का गोडाउन है, उसको भी चलने नहीं देते.
नहीं नहीं, वो भी
अनाज बनाए नहीं चाहिए क्या?
नहीं,
झारखंड
पूरा टोटल क्लोज था. कोई काम नहीं कर रहे थे.
एलिगेशन क्या लगा है? एफसीआई का गोडाउन.
हाँ हाँ ठीक है, एक पार्ट पे गोदाम था, बाकी और कोई इंडस्ट्रियल एक्टिविटी नहीं था. इसमें सीबीआई का रिपोर्ट आया, उसमें रिपोर्ट में भी एक बार देख लिया जाए. मेरा मान लीजिए इंस्पेक्शन गलत होगा, सीबीआई का रिपोर्ट तो गलत नहीं होगा.
Why the valuation was done? Why the valuation of the property was done? Valuation कब होता है प्रॉपर्टी का? ऑक्शन के पहले. क्यों हुआ? At the instance of the bank. बताइए, आप बताइए। आप बोलते बैंक का कोई लोन नहीं हुआ,
नहीं, जिस समय कैंसिल हुआ था
वैल्यूएशन क्यों हुआ?
मशीनरी वगैरह होगा या लैंड पर हुआ होगा।
ऐसे नहीं होता। Are you there? The godown is there.
The godown was functioning. That is the counter. The rent was paid from 2010 onwards to BSWC, Bihar State Warehousing Corporation. Now they have filed a rejoinder also. We are just saying that we had never authorized Bihar State Warehousing.
So how you enter into a rent deed?
There was no
Tenancy.
rent. There was no rent agreement, but there are some rent receipts because the Food Corporation of India has its own godowns, and where it does not have its own godowns, if other godowns of government agencies are available, in this case Bihar State Warehousing Corporation, so its rent was generated.
They say that it was never allotted to Bihar State Warehousing Corporation.
But we have annexed the rent receipts. We have also annexed a letter of the Bihar State Warehousing Corporation for 2012 reserving some space for FCI food stock. And BSWC was never made party also in these proceedings.
You are rank outside. आपके घर में घुस के कोई थर्ड पार्टी से एक एग्रीमेंट कर लेगा, रेंट उसको उसका हो जाएगा, टेनेंसी क्रिएट हो जाएगा। नहीं होगा ना। आप
And
अपने
in this-
सब्स्टिट्यूशन पहले
Yes, but while in the similar footing, Lord, once land was cancelled, the same has been restored. Similar footing. Common notice was given regarding the restoration of FCI material.
कहाँ
And
है बॉल?
supplementary kindly may be seen, Lord.
Who has restored it? This
Secretary,
order.
State of Government, Lord. The State of Jharkhand.
Where is it?
Supplementary affidavit may be seen, Lord. In appeal number 5/18.
Supplementary affidavit dated?
By the petitioner, Lord.
Dated.
Only one 12th appeal, Lord, I think. Only single supplementary by the petitioner, Lord.
Supplementary counter affidavit dated.
Supplementary affidavit.
अभी डेट बताइए ना।
I think in the year of 18 or 19, Lord. Not sure.
Supplementary counter. यहाँ पे चीफ सेक्रेटरी का एफिडेविट क्यों फाइल हुआ?
म्युनिसिपल कोर्ट द्वारा डायरेक्शन हुआ कितना यूनिट काम कर रहा है।
सप्लीमेंट्री एफिडेविट।
Kindly the order may be seen, Lord. In that order, it was considered that on the emergency situation, the FCI may keep grains in anywhere. That is not illegal. May read, Lord, the relevant part.
What do you have to say to this? क्या बोलना है आपको?
हाँ, इसमें स्टेट फाइल किए हैं काउंटर एफिडेविट, उसमें डिटेल दिए हैं, ये पढ़ दे रहे हैं।
इसका क्या जवाब?
हाँ, ये स्टेट फाइल किए हैं उसमें। ये है पैरा 11 एंड 12।
आप कौन है? और आप कौन है?
हम रेस्पॉन्ड नंबर 3 है बियाडा, ये है रेस्पॉन्ड नंबर 2 सेक्रेटरी इंडस्ट्रीज।
बताइए कहाँ?
ये पैराग्राफ 11 में लिखे हैं ये।
एक बार Lord order देख लिया जाए।
एफिडेविट का डेट बताइए।
एफिडेविट डेटेड है 13/4/2022। बहुत हुआ था उस दिन एफिडेविट की फाइल
10/4 का एक अकाउंट था। 13/4
30/4/22 के आसपास।
Filed by the Chief Secretary.
Chief Secretary.
हाँ चीफ सेक्रेटरी affidavit on behalf of the chief secretary government of Jharkhand. Order dated 15.
हाँ बताइए.
इसमें
Chief-
पैराग्राफ 11 से बोल रहे हैं, पेज नंबर 22.
बताइए.
That it is stated that the matter relating to the order passed by the Secretary Department of Industries Response number 2 in Messrs. Prasad Electrical is on a different footing. The Secretary Department of Industries Response number 2 allow appeal via memo number such and such dated 22/11/2018 and set aside the cancellation order issued by Response number 3 by letter number such and such dated 23/12/2013 because Messrs. Prasad Electrical had already removed the food grain
अरे
kept
भाई अभी रिमूव करा देंगे इंसान. आप क्या चिंता कर रहे हैं? हाई कोर्ट में केस चल रहा है तो कैसे ही रिमूव हो?
तो आज के डेट में तो वो बंद पड़ा हुआ कुछ नहीं है.
चालू कराएंगे ना. It is in the interest of all of us that something should happen in that plot.
अभी एक बार स्टेटस देख लीजिए, वहाँ चालू करने की स्थिति में होंगे तब ना.
ये चालू करेंगे ना. करेंगे चालू.
यस इंडस्ट्री यूज होगा
रिपोर्ट में एक बार
तो
सीबीआई की
मशीन
रिपोर्ट
सारा सड़
में
गया
दिया
होगा।
जाए.
कौन करेगा चालू?
सन है लोग उनके बेटे हैं
सीबीआई के रिपोर्ट में वो लिखे हुए हैं कि वो करने की स्थिति में नहीं है. उनके रिपोर्ट में लिखा हुआ है.
नहीं रिपोर्ट में ब्लड
सीबीआई डिसाइड करेगा.
नहीं वो रिपोर्ट में है, उनसे मांगा
उससे
गया.
क्या है? रिपोर्ट से क्या होने वाला है? रिपोर्ट से वस्तु स्थिति की जानकारी के लिए मांगा. रिपोर्ट का सीबीआई ये नहीं डिसाइड कर सकता है कि ये आदमी इंडस्ट्री सेटअप कर सकता है.
नहीं
That is the business
स्टेटस
sense.
तो बता सकते हैं ना. स्टेटस तो बता सकते हैं.
ब्लड सीबीआई का स्टेटस यही लिखा हुआ है कि वो जो डॉक्यूमेंट जो रिलेवेंट डॉक्यूमेंट पुराना डॉक्यूमेंट का डिमांड सीबीआई के द्वारा किया गया था वो
वो आपके
देने के
पास नहीं
पोजीशन में नहीं. ये नहीं लिखा हुआ कि करने की कंडीशन में.
इसको रेगुलराइज करने का क्या लेंगे आप? क्या सिस्टम है आप?
सिस्टम में फ्रेश अलॉटमेंट होता है. फ्रेश अलॉटमेंट होगा.
तब तो इसी ऑर्डर को सेटिस्फाई करना पड़ेगा अगर मेरिट में है. And what do you say? You will move or you want to stay over here? You are a rank outside. Maybe permissive possession through somebody who is neither the petition, maybe the petitioner also involved, but at least the Biada
Yes.
is not involved. Biada was
is
also
not-
involved.
No, Biada was not, but Bihar State Warehousing Corporation
That's-
issued a tender. In 2012 also extending some space for food corporation. So our only concern is if we have to remove, we may be given some time
You will
because
be
it
given
is food grain.
You
Only
will
that
be
is our
given
concern.
sufficient time for removal.
That is our only concern.
Or you can also enter into some arrangement if you want to. आप लोग तो
we
नहीं
are-
तैयार होंगे फूड ग्रेन के लिए. आपको खाना पीना तो नहीं चाहिए.
Because the entire district is being served, all these schemes.
आज के डेट में हमको जो इंस्ट्रक्शन है वहाँ पर अभी कुछ नहीं हो रहा. टोटल
फूड
बंद.
ग्रेन भी नहीं है.
कुछ नहीं, कुछ सब बंद है. पूरा जंगल झाड़ी है, पूरा शटर है. आज भी
He
हमको
says
सुबह
it is
में
there.
नहीं, इसीलिए तो बोल रहे थे एक बार
सील कर दिए
रिपोर्ट
तो
एक बार
लोग क्या
पैराग्राफ
करेंगे?
10 मेरा देख लिया जाए. पेज
देखिए,
नंबर
देखिए.
7.
अभी क्या बोलना है आपको बताइए. आप तो सब्स्टिट्यूट करिए. कहाँ है आप?
हाँ कर देते ब्लड
कब करिए?
वेट 2 वीक्स
2 weeks.
1 वीक कर देते जितना जल्दी
बस स्लो मोशन में चलिएगा तो कैसे ही क्या.
डेथ सर्टिफिकेट लगा है ब्लड और
2 weeks में क्या पता हम रहे ना रहे. तो दूसरा बेंच में दूसरा कार्य करिएगा. Always be there. ऐसा कुछ लॉ नहीं है नेचर का. WPC number 4309 of 2014. The learned counsel for the parties are present. The learned counsel appearing on behalf of FCI has submitted that the FCI had stocked food grain in the premises under the orders of
Bihar State Warehousing Corporation.
Bihar State Warehousing Corporation, and in case they are asked to be removed, some time may be granted. The Learned Council has also submitted that they were in permissive possession by virtue of such orders passed by Bihar State Warehousing Corporation. The Learned Council appearing on behalf of Bokaro Industrial Area Development Authority has submitted that Bihar State Warehousing Corporation has no authority to give permission to Food Corporation of India to enter into the plot allotted to the petitioner. He has further submitted that the entry of Food Corporation of India in the premises is not legal, and therefore the impugned action has been admitted. The Learned Council for the petitioner, in response to the submission of Council for Biata, has referred to his supplementary affidavit and has submitted that under identical circumstances, the relief was granted to the concerned industry, and the respondent by the Director of Industries,
Yes, Secretary.
by the Secretary Industries, who is the appellate authority. He has also submitted that the storage of food grain requires immediate attention, and therefore the allotment, therefore entry of Food Corporation of India in the premises cannot be said to be illegal. It has now been pointed out that the petition was filed by the sole proprietor, Mr. Ajit Kumar Sinha, who has expired. Counsel for the petitioner pays for some time to file an appropriate petition seeking substitution.
Kept on Friday, so that I can.
Post of Friday for supplementary list under the heading for orders. उसी से उनके ऑर्डर करेंगे, तो नोट वोट बना लेंगे, आपको बता दिए क्या करेंगे.
This Friday is holiday.
This Friday is holiday.
15th is Jharkhand.
But the next Monday, Tuesday supplementary list. सोच के आइए कैसे रिलीफ देना. इनका प्रोजेक्ट ही तो आएगा फ्रेश, और क्या आएगा. कितना इनको पैसा देना पड़ेगा.
1 एकड़ जमीन था वो टोटल, तो आज का जो प्रिवेलिंग रेट है वो रेट गए कम से कम. प्रिवेलिंग
रेट तो बहुत ज्यादा होगा ना.
हाँ, तो आज
और अगर एरियर पेमेंट करते हैं तो भाई अगर मान लीजिए कैंसिलेशन गलत होता है तो एरियर का ही तो पेमेंट होगा ना, या क्या होगा. दे हैव रिमेन्ड डिप्राइव्ड ऑफ द प्रॉपर्टी.
रेंट जो है बस वही रहेगा. सेटिसाइड होगा तो रेंट मिलेगा.
आप तो उनको डिप्राइव कर दिए, यूज भी नहीं करने दिए, अब रेंट भी आपको चाहिए. सोच के आइएगा रेंट देंगे
पोजीशन में रहेंगे तो
गलती इनका अपना माल रख के स्टेट गवर्नमेंट ऑफ याडा मिलके मेरा बंद करा दिया.
मेरा कोई चिट्ठी नहीं है.
प्राइवेट कोई माल रहता है तो समझ में
मिशन यही दी
ऐसा है कि 226 में पावर एक्सरसाइज करना होगा, तो शांति से पावर एक्सरसाइज करवाइएगा तो करवाइएगा, तो डिसमिस करने में 1 मिनट लगेगा, अलाउ करने में 10 मिनट लगेगा. ठीक है, तो सोच कर आइएगा आप एरियर ऑफ रेंट पे करेंगे कि नहीं करेंगे, सोच कर आइएगा, क्योंकि न्यू अलॉटमेंट इज गोइंग टू बी वेरी एक्सपेंसिव. राइट, कुछ तो बार्गेन होना चाहिए ना.
उसका भाड़ा भी बिलोड यही लोग खा गए आपस में, हमको दिए नहीं.
आप कैसा भाषा का प्रयोग करते हैं.
सॉरी टू use
हमारे
such
कोर्ट
language,
में इस
but
तरह का भाषा
no
का प्रयोग
agreement
मत किया.
no payment has been given to me regarding the same keeping the material of itself.
For admission item 8, CRNT 642 of 2016.
Yes, petitioners.
Petition praise for the passover.
क्या मैटर है.
The matter relates to the quashing of the order dated 1/2/2016, which is in annexure 1 of page number 52. Senior advocate Mr. Ajit Kumar has been engaged in this case.
Yes, yes, I just wanted to know what is the matter. Order क्या है? What is the nature of order?
The cognizance has been taken under section 354B of IPC.
Stay चल रहा है? Stay है?
Yes, sir.
आप किनकी तरफ से?
I am for the opposite party.
Cognizance has been taken under section
354B of IPC.
Right, right.
Lordship, the same matter, one co-accused has moved before my Lordship.
Co-accused has been?
Co-accused in this case, Ramavatar Sahu,
हाँ.
has moved Lordship has withdrawn this application. This is what order passed by my Lordship.
In case of another accused, you have withdrawn the case?
Yes.
आपको इसने क्या मानी?
बस
देखिए, बहस करना है तो फिर मेरिट पे भी ऑर्डर।
मेरिट
और विड्रॉ करना है तो बहस करने के बाद विड्रॉ नहीं करने के।
नहीं
You're challenging the order taking cognizance?
मतलब entire criminal proceeding including on merits Lordship will find I had given plus the small compilations also Lordship because by that it will be convenient. There is a small one plus because I am taking up the plus ground of malicious prosecution. Plus may I give plus a brief of the case in nutshell and then I will enter into.
You see, when you are on the order taking cognizance, you have to stick to the material which has been placed on record prior to order of cognizance.
Yes, yes, I am upon that. Well, the petitioner happened to be a Prant Pracharak of South RSS. They run various schools, and what had happened with respect to one school at Chaibasa. The husband of the informant had been the principal. On an incident which took place on the relevant date, which is here also.
Husband was the principal.
No.
Husband of the complainant.
Informant was the principal complainant. Yes.
Complaint है या informant?
Yes.
Complaint है कि FIR?
Complaint.
Investigation के लिए नहीं गया. It was not referred for investigation.
No.
Yes, please.
Yes. But our case is that before this case and after this case also, there had been similar allegations made about the same incident. So this is the case which is in the middle. Every detail Lordship will find. So if Lordship kindly have this, I am not going beyond records. I shall be arguing what is there on the records only. A Sadar PS case number 82 of 2015 was filed by the husband of the complainant for the same incident on the same day. Incident is of 10th of August.
Acquittal हुआ उसमें. Acquittal हुआ उसमें.
Sorry.
वो जो husband ने case
नहीं quash हुआ. दोनों quash हुआ. First case has been quashed and the last one has also been quashed. I am saying
there are 3 cases.
3 cases were filed by one by the husband for the same incident which took place allegedly on 10th of August 2015. It was under section 341, 323, 337 explaining same incident because what had happened. School was running, the husband of the complainant was a principal. Because of some bunglings and financial irregularities committed, the committee decided to remove him. So far this petitioner is concerned, he was positioned at Ranchi, but they have implicated everyone. The three cases, in the first case, Lordship will find that names the first case, Lordship kindly see, it is page number 105, 111, 110 it starts. It will start annexure 14, page number 107.
G.
107.
ये तो जजमेंट ये कंपाइलेशन से दिखा रहे हैं
नहीं, हम इसमें पेज बता रहे हैं, इसमें भी लगा हुआ है लेकिन हम रिकॉर्ड से
पेज
खाली
107.
पेज बता दिए. सॉरी, पेज नंबर 107. This was filed. This is the first case which has been quashed. This was under 156(3). Complainant was the husband of the complainant in this case, Surendra Kumar Rai. The name of the accused kindly fine. Several names Lordship will find. Then my name is at serial number 12. Then 19 persons were implicated, and the incident and discussion about that. Page 111, Lordship kindly see, she is arranged as witness in this case because she was also present, it has been said. Dharmshila Devi. Then details have been given that the complainant named principal of Padmavati Jain, so and so, Shishu Vidya Mandir, Chabasa, so and so, so and so. Then Lordship kindly straightway goes to para 5 of this thing. That on the same day, 8/8/2015, at about 4:30 p.m., 4:30 to 5 p.m., accused persons under serial number 1 to 19 physically assaulted Manju Devi at school premises by using criminal force with the intention of disrobing and tearing off her sari, compelling her to be so and so in public place, as well as same act with Dharmshila Devi. The accused persons were demanding so and so, so and so. Then this is about the incident they are discussing. Then para 9, that on being inquired, the legal status of the accused number 1 and 20 and its associates, accused number 1 to 19, the complainant got mentally shocked, so and so, so and so, so and so. Then Malas kindly see para 11. On 9/8/2015 at about 10 a.m., accused number 1 to 19 illegally disconnected the water supply and electric connections of the residential quarter of the employed teachers and other staff and misbehaved with the female members of the said quarter, and thereafter thrown the entire household articles into roads. And this was the complaint made. The complainant herein is the witness. Now let us kindly have the complaint here. Annexure 1.
No, what happened to this? Where is the order by which it was quashed?
It is in the complaint.
Let us see what is the nature of it.
Yes, yes.
कहाँ?
कंपाइलेशन में ये है, दोनों ऑर्डर लगाए हैं पेज नंबर 6 पे.
Was filed by all the accused persons. All 17 accused persons.
No. 70. They had been 19 accused persons.
दो तो नहीं है ना
8 से 17 तक
इसमें आप भी हैं क्या?
हम नहीं
आप
हमारा
भी है
नाम।
ना?
मेरा
और
नाम
आपके उस केस में क्या हुआ? आपके उसमें एक्यूज्ड है, आपका केस क्वाश हो गया?
मतलब द होल केस है बिल्कुल
होल केस कैसे क्वाश होगा? जिसके अगेंस्ट में जो जाएगा उसी का क्वाश होगा कि सबका क्वाश हो जाएगा? जो जाएगा उसी का ना क्वाश होगा।
मतलब मेरे हिसाब से केस तो क्लोज हो गया
क्लोज हो गया चाहे नहीं हो गया, we don't bother about it. But the point is that the case has been filed only. You are not a party in this.
I'm not a party.
Then
Yes. I'm not a party.
how do you say that the case has been quashed?
Yes.
There was a liberty granted to file a civil suit.
Civil suit. मतलब para 9 मतलब says where the aforesaid facts and arguments advanced by the petitioners as well as state court has gone through the material on record. It is an admitted fact that the dispute with regard to school OP number 2 has also opened school and the name of the school has been given the same name Padmavati Jain so and so. It appears that due to the name of the school dispute is there, that is why police submitted charge sheet showing the case civil in nature. The OP number 2 was dismissed from service by order dated so and so, and again this is not able to find appeal before the tribunal in which he has also. Some of the petitioners are members of the governing body and are
How do you say that the police filed a charge sheet showing that it is civil in nature?
It was in that case. It was referred to police.
Yes,
This
the
case.
final form was submitted by the police taking cognizance of offence punishable under section 452, 454.
Where not reading?
This one, page number 4, internal page 4,
Internal page 4.
page number 9. Final form was submitted saying what?
Page number, sorry, page number 9.
ऐसा है ना
एक
कि ये सब ग्राउंड पे हम इसको क्वाश नहीं करेंगे. आई एम मेकिंग माई माइंड वेरी वेरी क्लियर. अब आपकी मर्जी है. इफ यू वांट समथिंग ऑन मेरिट, this is not a ground for quashing.
I shall be arguing that if apparently the cases appear to be malicious.
दो आदमी में लड़ाई तभी होता है when they are otherwise in dispute. Incident किसी incident है, allegation है, ठीक है?
हम उस पे नहीं.
हम ये कर रहे हैं ना, अभी तो cognizance हुआ है बस.
नहीं, हमारा सिर्फ ये करना है.
ये जो सारी चीजें हैं ना कि दूसरा केस में ये ऐसा हुआ वैसा,
Second
these are all matter of defense and you are not even a party in those proceedings by which the proceedings are.
If I say that there have been 3 cases. There have been 3 cases lodged. First case is the version of the husband claiming that wife was present and the incident took place with the wife. The husband is claiming that in the first information
देखिए आपको बता रहे हैं
or complaint.
सेक्शन 300 का इंटरप्रिटेशन अभी हम कर रहे हैं और वही इंटरप्रिटेशन करके डिसमिस कर देंगे. आपका ट्रायल बहुत इफेक्टेड हो जाएगा क्योंकि 300 के नहीं यार, you see I am making it very clear to you because you see you are talking about another complaint filed by the husband. If the husband files a complaint, how will it affect the wife if she files another complaint?
Same version can be said differently.
Why not?
So
There can be 10
two FIRs
witnesses.
by 2 versions.
It is not a second FIR.
It is the second FIR.
Just a moment. The one of the cases you say is closed.
2 cases plus quashed, closed.
And in those cases no proceeding is going on.
एक बार देखिए, फिर इसलिए कहना, मतलब एक बार देखा जाए.
चलिए कोई बात नहीं, अब हम आपको कुछ नहीं बोलेंगे, हम आपको सुनेंगे.
हाँ, हम एकदम हम कहाँ बोल के सुन के आपको जो आप बोलिएगा कि हम ऐसा करेंगे हुजूर तो आपका
प्राइमरी फेसी इसीलिए हम बहुत लाउड एंड क्लियर बोलते हैं.
मतलब एकदम सही है
क्योंकि malicious prosecution का it's a matter of evidence. ऐसे
मतलब
malicious prosecution का finding नहीं दे पाएंगे.
malicious prosecution में कोर्ट ने कहा I am giving those judgments where the court has said कि the courts are supposed to read between the lines and there are instances मतलब compilation में देखा जाएगा जो हम rely कर रहे हैं to say and मतलब to argue out a case that it is a case out and out malicious and fit to be quashed in the light of the decisions of the Supreme Court. This is what I am saying. Now kindly straight away come to the compilation so that it will be convenient. It will be convenient. मतलब पेज 6 पे कंपाइलेशन में मतलब पेज नंबर 6 पे देखेंगे जो पहला एफआईआर है जो हम वहाँ पे पेज नंबर 9 वाला देख रहे थे। दूसरा एफआईआर जो है जो अभी क्वेश्चन के लिए है पेज 18 पर है मतलब वर्सन्स आर bit different but incident is same. Then पेज नंबर 25 देखा जाए थर्ड केस जब कर रहे 2017 में कर रहे Lordship looking at my compilation, the small one.
Version is different, but incident is same.
Incident is same. Version is changing, improving. Two malicious complaints are filed.
What is the additional point in the present case?
It's an out and out malicious case.
Additional point in the sense you just said that the version is different, but incident is same. What is the difference in the version?
Yes. Kindly Malos, for Malos convenience, please see Malos the convenience volume 3 वाला जो है, just to compare that, page 6 से देखिए, आपको बल्कि नई डॉक्यूमेंट देखना। ये इंसिडेंट है जिसमें कि वाइफ धर्मशिला देवी विटनेस हो रही हैं और आपको मैंने पारा 3 और 5 पढ़ा 3, 4, 5 kindly take note of that of page number 6 of the compilation छोटा वाला compilation वो मोटा compilation
ये वाला ना
नहीं दूसरा है
इसके अलावा भी कोई compilation
हाँ 2 एक डॉक्यूमेंट का है शुरू में आपने कहा
ये
वही इस तरह से
हाँ हाँ इसको निकाल दीजिए
सॉरी बोला इसका 2-3 खाली पैराग्राफ पूरा नहीं पढ़ाएंगे जस्ट टू सेव योर लॉर्डशिप प्रेशियस टाइम भारत पेज मतलब पेज नंबर 11 देखा जाए पारा 3 ऑफ द कंप्लेंट जो स्टार्ट हो रहा है पेज नंबर 6 से उसका पारा 3 देखा पारा 3 खाली उसको देख लें that on 8/8/2015 at 3 p.m. time is also same. Above named accused persons, namely so and so, all associate accused number 20 and few unknown persons possibly entered into official chamber, etc. Then, para 4. Then, para 5. Here, what is important? That on the same day, on 8/8/2015 at about 4:30 to 5 p.m., accused persons under serial number 1 to 19 physically assaulted. पढ़ दिए यहाँ मतलब काइंडली राइट मार्जिन में लिख लिया जाए there is no reference of any police authority being there. बाद में क्लेम किए कि पुलिस भी था वहां, पुलिस के सामने घटना हुआ, ऐसा क्लेम किया। पारा 5 के मार्जिन में there is no reference of any police authority being present at the place of occurrence. Then para 11. Here also, Lordship, kindly note in the margin, right? There is no reference of any police. No reference of any police. And this aspect is very, very important. Then para 14. That para 14 is important, that the complainant immediately rushed to local police. So after that they say rush to local police station, Sadar Chaibasa, and Superintendent of Police for registration of first information report. They claim so complainant is present in Chaibasa after all these incidents. Now let us kindly come to the FIR complaint in hand. Para 14 यहाँ पे राइट मार्जिन में अगर नोट कर लेंगे कि कंप्लेनेंट इज प्रेजेंट इन चाईबासा एज पर दिस वर्सन।
उसमें कहाँ प्रेजेंट?
हम देखा किसमें?
इसमें भी
अभी दिखा देते हैं हम दिखाएंगे, खाली राइट मार्जिन में लिख लीजिए तो
पेज नंबर 113
जी बस पेज 18 में भी है। पेज 18 ऑफ कंपाइलेशन में है।
अच्छा कंपाइलेशन
है
पेज 18
जी। उसी में है जो पेज 18 में।
अच्छा ये प्रेजेंट कंप्लेंट
जी,
ये प्रेजेंट कंप्लेंट ठीक
प्रेजेंट। अब देखा जाए इसमें क्या करते हैं कि नाम कंप्लेनेंट हो गई वाइफ, उसमें हस्बैंड थे, इसमें नाम घट गया, वहाँ पे 150 आदमी एक अननोन थे, यहाँ पे 1 2 3 7 8 so अनिल कुमार मिश्रा एंड 10 12 अननोन पर्सन्स। एक तो वाइटल एस्पेक्ट ये आया, दूसरा देखा लिस्ट ऑफ विटनेस में यहाँ हस्बैंड है हु इज क्लेम टू बी प्रेजेंट। पेज 19 में लिस्ट ऑफ विटनेस में अपने हैं और सुरेंद्र कुमार राय उनके हस्बैंड है। नाउ लेट्स काइंडली कम पेज 20। टाइमिंग समय सब सेम है, पेज 20 देखा जाए इंटरनल पेज 3 ऑफ दैट कंप्लेंट, मतलब द प्रेजेंट कंप्लेंट इन व्हाट्स यू गॉट जी। पैरा 2 on 8/8/2015 same date at about 3 p.m. time to 5 p.m. the accused persons named under serial number 128 and 10-12 unknown persons physically assaulted complainant at school premises by using criminal force with intention of disrobing so and so her dresses, sari, so and so, so and so. Exactly same जो वहाँ पारा 12 में है, इसका अगर राइट मार्जिन में लिखेंगे मतलब सेम टाइम सेम इंसिडेंट, पेज नंबर मतलब 11-12 में है। नेक्स्ट पारा 3 दैट ऑन 9/8 on 9/8 about 11 a.m. to 2 p.m. that is Lordship will find in the first complaint of the husband, पेज 14 में पारा 11
ये 8/8/2015 का इंसिडेंट पुराना वाला एफआईआर के किस पैराग्राफ में?
जी जी पारा 12
पैरा 10
सॉरी हाँ पारा 3 and 5 पारा 3 सॉरी पारा 3 8/8/15 at about 3 p.m. What's you got?
and at about 4:30 to 5
हाँ वो वाला है पारा 5 में। What's you got?
तो
पारा
एक पैरा
3 पारा 5 जी। अब ये लिखते हैं फिर 9 तारीख का इंसिडेंट है, वो फर्स्ट एफआईआर में फर्स्ट कंप्लेंट में पारा 11 में। What's you got? पहला वाला में 9/8/2015 का। अब यहाँ पढ़ा जाए para 3 of the complaint in hand. On 9/8/2015 at about 11 a.m. to 2 p.m. Date वही है, timing वही. All the accused number so and so along with 10-12 unknown persons forcibly entered into a residential house in absence of so and so so and so. This right margin में लिख दिया जाए, मतलब to compare with the first complaint का पेज 14 पारा 11 में है, और पेज ये है so and so बहुत सारा गंदा चीज जरूर लिखे हैं. The complainant under और should I read मतलब
नहीं ठीक है, हमको नहीं सुनना.
इसमें पिस्टल उस्टल सब लिखती है, उनकी पत्नी लिखी. No person forbidden the residential house in absence of husband started abusing filthy language. They made demand of so and so, and on denial they all on pistol point. Because these pracharaks will go and show pistol to them. So on pistol point in the fear of instant.
ऐसा कोई लीगल बार है क्या?
मतलब जो हमारी आस्था है
आस्था से नहीं
generally,
चल सकते ना, record से
whether
चल.
these persons who are doing these kind of social work, they devote their whole life to such things.
I can't give a finding. You can argue.
उस पे हम generally बोले, मतलब I'm not asking your lordship to give such finding. Yes. Anyway, then अब देखा जाए, ये पूरा पैराग्राफ आया, पारा 4 देखिए. That the complainant reached 10:30 p.m. night on the same day at her another residential house, so and so धुरवा. वहाँ पे वो पुलिस के पास FIR कर रहे थे, पहला कंप्लेंट के हिसाब से चाईबासा में, और यहाँ पे ये 10:30 बजे रांची पहुँच गए और घटना कुछ और हो रही है. ये इनका इम्प्रूवमेंट चल रहा है कंप्लेनेंट में.
कहाँ लिखा है कि हस्बैंड के साथ आए?
हम वो दिखा, गवाह हस्बैंड गवाह है और उसका हम दिखा देंगे, एक और FIR दिखाएंगे, क्लियर हो जाएगा कि क्या ही लोग कर रहे हैं. दैट कंप्लेनेंट रीच्ड सो एंड सो, मतलब so and so another residential house so and so at 11 p.m. Accused persons under so and so chasing her from Chaibasa to Ranchi came to Ranchi, entered residential house so and so. Then kindly come, page 20.
इसका क्या हुआ? इस
इसका
कंप्लेंट का क्या हुआ?
क्वेश्चन
ये कौन सा केस था?
जी, ये वाला क्वेश्चन हुआ पेज नंबर 13, जो मोटा वाला कंपाइलेशन है उसका पेज नंबर 13 से 16. इसमें देखेंगे कि हस्बैंड कहाँ थे, वो क्लियर. इसमें हम अक्यूज्ड ही नहीं थे. थर्ड वाले में आई वाज नॉट इवन अक्यूज्ड फॉर द सेम इंसिडेंट्स. आई एम नॉट अक्यूज्ड, और ये केस है पेज नंबर 13 पर. आई वाज नॉट मेड अक्यूज्ड एनी इंसिडेंट्स आर सेम. बस काइंडली सी पेज नंबर 25 पे, ये भी कंप्लेनेंट का ही है. पेज 25 पे धर्मशिला देवी, ये देख लिया जाए. एड्रेस ऑफ द अक्यूज्ड जो लिखा है उसमें आई एम नॉट मेड अक्यूज्ड इवन. इंसिडेंट्स काइंडली सी. डेट ऑफ अकरेंस 9/8/15 to so and so. Then मतलब काइंडली सी पेज नंबर 5 पारा 5. That is stated that on 8/8/15 the members and office bearers of Vidya so and so with the help of local district administration, यहाँ पे एडमिट कर रहे पुलिस था, डिस्ट्रिक्ट एडमिनिस्ट्रेशन था, forcibly entered the premises of the state school by breaking open the locks of all the rooms, physically, verbally abused the complainant so and so and her husband, asking them to vacate. Then kindly come para 7. it is stated that complainant with the support of other office bearer the school continued to stay in the said residential quarter. That it is stated that on the next day, 8th का घटना कुछ नहीं लिखे, 9th, 8th का. That it is stated that on next day itself, on 9/8/15 at about 3 p.m. the accused persons and some persons along with police constables, यहाँ पुलिस आ गया है, उसी घटना में पुलिस भी था, डिस्ट्रिक्ट एडमिनिस्ट्रेशन एडमिटेड है. Police constables came to the quarter of the complainant and started misbehaving with her, asking her to vacate the quarter. So and so, so and so, so and so. Contacted her husband, who was then compelled to stay at Ranchi. अब यहाँ पे husband रांची में आ गए. Then para 9 देखा. That is stated that complainant immediately rushed to the nearest police station. 9/8/15 को मतलब पूछे कि husband था वहाँ थाना में, तो ये तो नहीं थी ना, लेकिन मतलब पारा 9 में खुद क्लेम कर रही है that stated that complainant immediately rushed to the nearest police station Chaibasa, leaving the quarter open. When the policemen who appeared to be in connivance with the accused persons kept the complainant waiting for 4 hours, and at least they forced complainant to write that she is vacating the said quarter along with her necessary so and so with 4-wheeler, necessary belonging with 4-wheeler. It is pertinent to state that during the aforesaid period of 4 hours, from 3 p.m. to 7:30 p.m. on 9/8/15, the door of the quarter was left open. ये बोलती है कि वहीं पे 4 घंटा हम थाना में थे. तो how could she claim in the police complaint in hand that she came to Dhanbad, she came to Ranchi, Dhurwa? Now, मालूम पारा 11 देखा जाए. That is stated that after coming back to her residence at about, मतलब देखा जाए पारा 11 में इनका claim. That is stated that after coming back to her residence at about 7:30 to 8 p.m. पारा 11, sorry मतलब पेज 30 का 9th का ही घटना वो क्लेम कर रही है. That is stated after coming back to her residence at about 7:30 to 8 p.m. on the same day, the complainant somehow managed to take out some unnecessary belongings not allowed by the. So she is at Chaibasa as per her own claim till 8, and within 2 hours, how she can come to Ranchi is a big question. Which route she will take or anyone will take to reach at Ranchi at time which is claiming. So my contention is that 2 complaints have been filed, one by the husband in 2015, second is after the husband's complaint on to in few days date of the complaint. First one date is first one is filed on 24th August. 22nd.
Sir, the PS is 10th of August 2015.
Yes.
The
Second
complaint
is
is 111 of 2015 is dated.
ये वाला है 24/8/2015 जो केस इन हैंड है. कंप्लेंट इन हैंड 24/8/15 का है जो उनका एफिडेविट है. और पहला जो कंप्लेंट
आपने 4 कंप्लेंट की बात की.
3
नहीं, इसमें 4 है.
एक तो कंप्लेंट हम लोग किए थे स्कूल से रिलेटेड मैटर, वो चल रहा है. एक
एक
कंप्लेंट
सेकंड, ये चार्ट में आइए.
जी मैम,
ये सदर पीएस केस 82 of 2015.
ये हम लोग फाइल किए थे.
Petitioner's complaint, school's complaint.
ये इट इज रामवतार साहू इज वन ऑफ द accused. One of the accused alleged that husband of the petitioner was not complying with the transfer order. So committee के लोग हैं ये
मतलब इससे आपको कोई मतलब नहीं है. स्कूल का कंप्लेंट.
हाँ,
ये जो कंप्लेंट है ये वाला
ये
111 of 2015.
ये 111 of 2015 है. ये फाइल हुआ है 22/8/15.
22/8/15.
इंसिडेंट इज ऑफ,
इसमें क्वाश हो गया.
ये क्वेश. And according to my information,
Case is closed.
case is closed. देन
उसके बाद कंप्लेंट 2102
2102 अभी वाला है, जो
Present.
अभी वाला है, जो अभी जिस पे हम लोग
उसके बाद कंप्लेंट 426 2017
जी,
ये कब का है?
ये है 22, ये वाला सेकेंड वाला का डेट लिख लिया जाए 24/8/15
24/8/15 को फाइल।
हाँ 2102
ये वाइफ ने फाइल किया।
ये वाइफ ने किया 24/8/15
कंप्लेंट 111 हस्बैंड ने फाइल किया।
हाँ जी,
ठीक है।
111/2015
और ये कंप्लेंट 426 2017
ये फाइल हुआ 2 साल 22/11/2017
कौन फाइल किया?
wife about the same incident and admitting that district administration was very much present.
इसका डेट ऑफ फाइलिंग बताइए।
इसका डेट ऑफ फाइलिंग है 22/11/17 22/11/17 और इसमें ये कहती हैं कि डिस्ट्रिक्ट एडमिनिस्ट्रेशन और पुलिस के लोग थ्रू आउट 8/8 को भी थे, 9/8 को भी थे। सो इंसिडेंट जो भी हुई थी वो, और वो पुलिस थाने में थी, 8 बजे तक घर पे थी। चाबासा में वो है दिस
मतलब डिफरेंट वर्जन है,
डिफरेंट
कॉन्फ्लिक्टिंग वर्जन,
कन्फ्लिक्टिंग वर्जन, इनकंसिस्टेंट और इनकंसिस्टेंट वर्जन के साथ में हम ये वर्ड यूज कर रहे हैं कि मैलिशियसली प्लस क्राफ्टेड complaints. Generally complaints are drafted by the persons, the lawyers maybe, but these are maliciously crafted complaints, and this case is, according to me, is a clear case of malicious prosecution. When same incident is being अब जजमेंट्स पे देखेंगे, इसका इंटरनल पेज 5 देखा जाए जजमेंट्स में, मोटा वाला जो पहला माधवराव सिंधिया मतलब जनरल प्रिंसिपल्स पे है, 12 हम लिखे हैं, 12 से देन मतलब दूसरा भी है जनरल प्रिंसिपल्स पे है, तीसरा भी जनरल प्रिंसिपल्स पे पारा लिखा हुआ है। देन पारा सीरियल नंबर 4 इज इम्पोर्टेंट, ऐसे भी प्लेसिंग दोस पैराग्राफ्स। अहमद अली कुरैशी वर्सेस स्टेट ऑफ उत्तर प्रदेश, हियर सुप्रीम कोर्ट सेज 2020 वॉल्यूम 13 SCC 435 that malicious prosecutions must be quashed. Para 10 and 16 page 38। इसका अगर पेज 43 देखा जाए तो पारा 10 शुरू हो रहा है, भजन लाल का प्रिंसिपल्स पैराग्राफ 102, पारा पेज 43 में
फैक्ट पढ़िए, इसका फैक्ट पढ़िए।
पढ़ जी। The appellant accused and respondent number 2 complainant belong to the same family and are neighbors. The father of accused so and so Haq and filed so and so against the complainant in the court of civil judge. With regard to partition of property, which suit is still pending. Suit between parties led to several altercations among the parties. On so and so a quarrel took place between the parties. The police went on the spot of incident on 19/7/16 itself and initiated proceeding against section so and so. Proceedings were drawn under CRPC against both the parties to maintain peace. On 29/16 an application under section 156 CRPC was filed by the complainant Sajid so and so against the accused so and so as well as their father so and their 3 other brothers, referring to incident dated 19/7 at about 6 p.m. Allegations complaint was
We will continue this.
Minus?
Date by.